To all, this is Shaurya Raj, intern at ubAdvocate and a first year law student. I will be talking about custody of child. There are three types of custody: physical, joint and legal custody. Physical custody pertains to the when one spouse is granted the custody and the other is granted visitation right. The second is joint custody, when the custody is granted to both the parents and they take turn by turn to ensure the well-being of the child. Third is the legal custody. In legal custody, both the parents are obligated with this custody and they have the right over the education, medical treatment, and other basic necessities that the child needs. There is also fourth type of custody which pertains to the interim custody. When a divorce petition is filed and for the time being whenever the judgment is held, for that time period the interim custody can be granted by whosoever files the petition for it, keeping in mind the best interest and the welfare of the child, keeping the welfare and best interest as it is the most paramount consideration in the custody of child. There are numerous sections of laws in our country which pertains to the custody. There is section 26 of the Hindu Marriage Act 1955 which pertains to the interim custody of the child. There is section 7, 9 and 12 of Guardianship and Wards Act 1890 and section 13 of Hindu Minority and Guardianship Act 1956 which state that the welfare of child is paramount importance in terms of the custody. This has also been stated in numerous judgment of our honorable courts of our country. To state one such case, in the Supreme Court case of Vikram Veer Vora versus Sarini Bhalla, the Supreme Court was of the view that the paramount consideration is the welfare of child in matters of custody, and it may even have primacy over statutory provision. The second most essential ingredient is the best interest of the child. This has also been stated in numerous judgments of our countries, numerous judgment of the courts of our countries. To state one such case, in the case of Lahari Sakumuri versus Soban Kodali, that the Supreme Court held that the best interest of this child should not be only limited to the primary and the love giver, that is the mother, but took a wider connotation and said that it should also include the intellectual and emotional well-being of the child. While granting the custody, the important question is also the natural guardian. The natural guardian is the father, as is stated in the section 6A of the Hindu Minority and Guardianship Act 1956. But the custody is granted to the mother when the child is not have completed the 5 years, as a mother can provide all the necessities of child. So the child is also at such a tender age as he can provide the basic necessities for his survival, so that he does not get any morbidities. While granting the custody, the first thing that the court does is reconciliation of the marriage, as they don't want the child to get neglected of either of the father or the mother love, and they try to ensure in the best interest of the child. Thank you.